So thank you very much, Zaza. There is a PowerPoint. Good. So I don't have to do anything, you'll move aside if I give you a nod. Is that okay? So thank you very much, Zaza, for the invitation to address you this afternoon. I'm now an academic, but I did start my professional life as a criminal defence lawyer and was what we would call a police station lawyer for many years at the time when the right of access to a lawyer at the police station was first introduced in England and Wales, which was back in the 1980s. And what I want to talk about today is just four things in the short time that I have available. Firstly, I want to look at what early access means, or how to define it. Secondly, to just say something about the special characteristics and demands of early access. And then move on to what I've called the four requirements for making early access effective, which I've largely taken from the handbook that you have in your materials, which, as Zaza said, I played a large part in drafting. And then, if I have time, to say something very brief about the early access scheme in England and Wales, but if I run out of time, I can always do that later on in the session. But I think it's worth just saying a couple of words first about why early access to a lawyer or to legal assistance is critical. And there's a very basic reason, which is relevant in many countries, which is that early access to legal assistance is a fundamental safeguard against ill treatment. And that's a rationale which, for example, the Council of Europe Committee for the Prevention of Torture puts forward as being an absolutely essential safeguard against people being tortured and ill-treated by the police and other law enforcement agencies. But it's also, the right of access to a lawyer is also a fundamental feature of the right to fair trial. And the way that I like to express it is that the trial starts at the police station. The trial starts at the police station, and as the European Court of Human Rights in the Salduz case recognised, it's there at the police station where what happens in any particular case is going to be determined. And in fact, also for some people, the police station is the only place in which they will experience the criminal justice system if they live in a jurisdiction which has mechanisms for diverting people from the courts, what you might call out-of-court disposals. So that stage is absolutely fundamental to the criminal process. So if we could move on to the next slide. So, yes, we felt it was important for the purposes of the handbook, but I think it's important in any particular jurisdiction to define what early access means. What are the parameters of early access? And so this is not a foolproof definition, but we set this out on page Roman numeral 10 of the handbook, and I'll just go through it very briefly. But early access to legal aid means access to legal aid from the time that a person is suspected of, arrested or detained in respect of, or charged with a criminal offence, whichever is the earliest, and throughout the period up to and including the first appearance before a judge for the purpose of determining whether the person is to be detained or released pending trial. So that was our attempt at trying to define what is meant by early access, although in any particular jurisdiction it may need some adjustment because across different jurisdictions the police are regulated in quite different ways in terms of the amount of time for which they can keep a person in police detention, and also the timing of the first appearance before a judge varies enormously across different jurisdictions. But I think just a couple of critical things about that definition is, as someone said yesterday, that arrest is given a substantive, a factual definition rather than a formal definition. So the question is, has a person, as a matter of fact, been detained by the police or a law enforcement agent in relation to a suspected criminal offence? And that term arrest is defined in the UN body of principles for the protection of all persons under any form of detention or imprisonment. That's where for the purposes of the handbook, we took that definition, but it's basically has a substantive meaning than a merely formal or legal meaning. And a detained person means any person deprived of personal liberty except as a result of conviction for an offence. So that's the way of trying to define it. So we'll move on to the next slide, the particular demands of early access to legal aid. And these are demands that we've been hearing about anyway during the course of today in particular, and many of you will be familiar with. But I think it is worth just spelling them out because they have to be taken into account in designing an effective early access scheme. Firstly, demand for legal aid at the early stages of the criminal process is unpredictable, and it requires a 24/7 capacity to respond. It's no good if the legal aid provider can only promise to attend the police station, the following day or in 12 hours' time. The demand is immediate, but it is also unpredictable, and therefore legal aid service providers need to be organised in such a way that they can meet that kind of demand. Secondly, cooperation of the police and law enforcement agencies is critical to facilitating early access because they are the gatekeepers. So they are the people who need to be informing people of their rights of access, of facilitating that access, and of allowing access by the lawyers or the paralegals when they do attend. And also, they need to be able to be relied upon to adjust their investigative actions, to take account of any right of access to a lawyer. Because the right of access to a lawyer is not going to be very useful if the police can simply carry on with interrogation whilst they're waiting for the lawyer to attend. But a third demand or challenge is, as we know, that the police and law enforcement agents have their own agendas, their own timescales and their own pressures. And that's something which has to be considered and catered for in any early access scheme. And then fourthly, that suspects at this stage are at their most vulnerable. And the reality is that the vast majority of people arrested and detained around the world are relatively poor, are relatively ill-educated, are disadvantaged for a range of other reasons. And they are often placed in seriously overcrowded conditions, which are breeding grounds for torture, criminality, corruption, and dangerous diseases. So it seems to me that those four things have to be recognised in determining how, in any particular jurisdiction, you're going to design an effective early access scheme. So if we go on to the next slide. So these are what I would say, thank you, are the four requirements for early access. And what I'll do is I'll just go through them briefly and I can always expand upon them later. And as I say, this in particular is taken from the handbook. The first requirement is a legal framework that guarantees early access and which guarantees in detail how it is to be facilitated and delivered. And it may be an obvious point, but that is absolutely critical. If the law is not clear on the right of access, then it has no chance of being effective. And let me just take one example. I don't particularly want to pick out the Netherlands, but I'll pick out the Netherlands because I've recently done some research there. And the law does provide for a right of access to a lawyer at the police station, but it does not provide for a right of that lawyer to attend the interrogation of their client. And the consequence, as you would predict, is therefore they don't, because the police won't allow them in. And I know that's an obvious point, but it does underline the necessity for close attention to be paid to the legal framework. The second requirement is for organisations, mechanisms and procedures for delivering early access. And by that I include both the organisations that are going to provide it. Are they going to be private lawyers? Are they going to be public defenders? Are they going to be paralegals? Are they going to be law centres, justice centres, etc.? But also the mechanisms for delivering early access, and in particular, and one that we have heard about is the duty lawyer scheme. And it's been my experience in the research I've done in a whole range of jurisdictions that duty lawyer schemes of one kind or another are absolutely critical to delivering early access effectively. So I've run out of time, so I just mentioned then that those other two, and we've been hearing about this to a certain extent in the last session, not only a sufficient number of lawyers or legal aid providers, but a sufficient number who are skilled and knowledgeable and willing and able to provide early access. And that's been, I think, quite a problem in some jurisdictions, is how do you actually motivate lawyers to actually want to do this work? So I'll finish at that point, and then I can deal with other things later on in the session.